Welcome to the Scaringi Law Lunch Minute. This is your time of the day to learn a little bit about the law while you enjoy your lunch. In the area of business law, in prior videos, we talked about the importance of protecting your rights to intangible assets, such as logos and brand names, by registering them as trademarks and service marks. Your rights as an author to computer codes, songs, photographs, by registering those as copyrights. We also spoke about the formation of a limited liability company and doing business through this business entity in order to reduce your personal liability. Today I would like to talk about business acquisitions. If you are acquiring the business of another, you want to make sure to protect yourself and your business. The first issue is whether to do a stock or an asset acquisition. As the buyer, you will want to do an asset acquisition. One of the chief benefits is you will be, or you should be, acquiring only the assets and not the liabilities of the business. If you structure your deal as a stock acquisition, then you'll be acquiring all of the liabilities associated with the business in addition to its assets. So the general rule is sellers like to sell stock and buyers like to buy assets. Another consideration is the allocation of the purchase price of the business, the price you're paying for it. You should include an allocation section in your purchase agreement. The general rule is sellers want to characterize the sale in such a way that gives them capital gains tax consequences, and buyers want to characterize the sale in a way that provides the seller with an ordinary income tax consequence. The seller has to pay the tax. Whether it's characterized as a capital gain or an ordinary income tax is a matter of negotiation. Generally, capital gains tax rates are lower than ordinary income tax rates, which is why sellers prefer capital gains. Buyers prefer an allocation that results in ordinary income to the seller because the buyer gets faster deductions off his own income tax obligations for assets he has acquired that are characterized as taxed and as ordinary income. For example, furniture, fixtures, and equipment. This is just one example. The larger the business, the more significant the tax consequences are to the seller and the buyer. Generally, the seller and buyer have divergent positions on allocations of the purchase price. It's important to negotiate that and get it in your agreement so that there's no dispute later. Another consideration if you purchase a business is to make sure you have the seller of the business agree not to compete with you after the acquisition. For example, if you are purchasing a professional practice, such as a dental office, make sure you have what is called a covenant not to compete in your acquisition agreements to make sure that the dentist doesn't sell you his practice and then turn around and resume his practice or join the dental practice of another. Not that any dentist would do that. We love our dentists. There is so much more that goes into the purchase of a business. So make sure you talk to your business attorney and get him or her involved at the earliest stage possible. If you have any questions about business law or the acquisition or sale of a business, give me a call at 717-657-7770. Well, I hope you've learned a little bit about business law and acquisitions. If you have any other questions, give me a call or check out our website, scaringilaw.com. That's about all the time we have today for the Scaringi Law Lunch Break. Enjoy your lunch.